You're sitting across from a police officer and he sounds like he's on your side. Calm voice, friendly tone, maybe even a little sympathetic. He's not reading you your rights. He's not threatening you. He's just talking. And that's exactly the moment most people get themselves in trouble, because everything he's about to say next is legally allowed to be a lie. Here's what's actually at stake. The words that come out of your mouth in the next 5 minutes can end up being the entire case against you, not because you did anything wrong, just because talking gives police something to work with, and they're trained to work with almost anything. Innocent people talk their way into trouble constantly, precisely because they assume the truth will be enough to protect them. It usually isn't, not in that room. So today, we're going through the specific lines officers are trained to use to get you talking. Why each one works on people who've done nothing wrong, just as easily as it works on people who have, and the exact words you can say instead that protect you every single time, regardless of guilt or innocence. Let's start with the legal reality behind all of this, because it explains everything that follows. Back in 1969, in Frazier versus Cupp, the Supreme Court ruled that police deceiving a suspect about evidence during an interrogation doesn't automatically make a confession involuntary or inadmissible. In plain terms, officers are legally allowed to lie to you, not bend the truth, not exaggerate. Lie outright about evidence that doesn't exist, about confessions that were never made, about tests that never happened. And once you understand that single fact, every line on this list stops sounding like a threat and starts sounding like a script. Line 1, I can't help you if you don't talk to me. Not true in either direction. Nothing said in that room is capable of helping you. An officer isn't in a position to make your situation better based on what you say, only to use it. The more you talk, the more material you're handing over to be interpreted, twisted, or stitched together with other information. Every word is a brick they can use to build a wall around you, and none of them can be used to help you climb out. Line 2, come down to the station, I just want to hear your side of the story. This one works because it sounds so reasonable, but that's not how it plays out once you're actually there. These are trained interrogators, not neutral listeners. The moment you're in that room, you're not telling a story in your own words. You're being hit with a sequence of yes or no questions where the answers are already decided in advance. That's an interrogation, dressed up as a conversation. The only place your actual side of the story carries any real legal weight is a courtroom in front of a judge with your attorney present. Line 3, this conversation is off the record. There's no such thing, not with a police officer, not ever. The instant you start talking, everything you say can and will be used in court, whether he called it off the record first or not. That phrase exists purely to lower your guard. The correct response here is simple, and it should become automatic. I'd like to have this conversation with my attorney present. Until then, I'm invoking my right to remain silent. Say those words out loud. Courts have made clear that simply staying quiet isn't enough on its own. In Berghuis versus Thompkins, the Supreme Court ruled that you actually have to state that you're invoking your right to silence for it to take legal effect. Silence alone can be interpreted differently. The words matter. If this is already changing how you'd handle a conversation like this, subscribe now, because the tactics get sharper from here, and you'll want the rest of this playbook before you ever need it. Line 4, I'll personally talk to the judge and prosecutor if you cooperate. Almost never happens the way it's implied. Detectives rarely speak to a judge or prosecutor about your cooperation at all, and judges are focused on one thing, whether there's enough evidence to establish guilt, not whether you were polite and talkative during questioning. The few times you'll actually see a detective admit to saying, this is under cross-examination at trial, when it's already too late to matter for you. Cooperation rarely earns any real benefit. Talking, on the other hand, can cost you everything. Line 5. Someone else already confessed and told us what you did. Even taking that at face value, it changes nothing about your legal position. It doesn't obligate you to respond, and it doesn't guarantee the police will treat anything you say more favorably. This line exists purely to make you feel like the decision has already been made without you, so you might as well talk. Stay silent regardless of what they claim someone else said. Line 6. We already know what happened. It's going to get worse for you if you don't talk. Walk through the logic here for a second. If they genuinely had enough to know exactly what happened, they wouldn't need you to confirm it. They'd have already arrested you. And if they don't actually know, nothing you say is going to talk your way out of the situation. Because an officer who already believes you're guilty is going to interpret whatever you say to fit that belief. Everything becomes evidence when someone's already decided what the evidence should show. Line 7, specific to DWI, stops. Just take this breath test, and I'll let you go home. Officers offering a breath test in this context are typically building a case for guilt, not confirming innocence. Even blowing under the legal limit doesn't necessarily end things. That result often gets paired with your performance on field sobriety tests to build a combined case that gets you off the road for the night regardless of the exact number. Line 8. We found your fingerprints at the scene of the crime. Ask yourself the obvious question. If they actually had a confirmed match, why haven't they arrested you yet? Fingerprint matching isn't instantaneous, and it requires an existing set of your prints on file to compare against in the first place. If officers show up shortly after an incident already claiming a fingerprint match, the timeline alone is a strong signal they're bluffing to see how you react. Line 9. We already have an eyewitness putting you at the scene, or its close cousin. We pulled the footage from across the street, and we already know it's you. Same underlying logic applies here too. If police genuinely had a witness statement or clear footage placing you at the scene, an arrest would typically already be happening instead of a conversation. This particular lie tends to work hardest on people who've done nothing wrong, because innocent people panic at the idea of being falsely placed somewhere, and panic makes people talk. Line 10. We can get a search warrant in just a few minutes. It's easier if you just let us in now. The correct response here, word for word. Officer, I do not consent to a search of my vehicle or my property. Whether or not they could actually secure a warrant quickly is beside the point. If they already had enough evidence to get one, they'd typically have shown up with it already in hand. What you're usually hearing is a fishing expedition, hoping you don't realize you're allowed to simply say no. The moment you consent to a search, you give up the ability to later challenge any evidence found on the grounds that it was obtained without a proper warrant. Line 11. Hey, your friend already ratted you out. A classic move on traffic stop specifically. Officers separate the driver and passenger, question each individually, then tell one that the other already placed the blame on them. If police genuinely had that kind of statement against you already, they wouldn't need to negotiate for a confession. They'd simply make the arrest. The correct response stays consistent here too. I'm exercising my right to remain silent, and I want my attorney present for any further questioning. Line 12. You just failed the polygraph. First, and most importantly, never agree to take a polygraph examination for law enforcement in the first place. The results aren't even admissible in court, which is exactly why this particular lie exists. Some officers will falsely claim you failed one anyway, not because the result means anything legally, but because it applies psychological pressure aimed purely at getting you to talk your way into an actual usable confession. So here's the pattern running underneath every single one of these 12 lines. Almost none of it is really about hearing your side of the story. It's about collecting anything usable, by whatever legal means are available, and as Frazier v. Cupp makes clear, the law allows quite a lot of room for deception along the way. Notice, too, that the lines fall into two rough categories. The friendly ones, dressed up as cooperation and a chance to help yourself, and the pressuring ones, dressed up as evidence that's already stacked against you. Both categories are aimed at the exact same outcome, getting you to open your mouth before you've had a chance to think it through. Which means your actual response barely needs to change no matter which version of the tactic you're hearing in the moment. If it's a request to talk, invoke your right to remain silent clearly and out loud and ask for your attorney. If it's a request to search your car, your home, or your property, say plainly that you don't consent. Say it calmly, say it clearly, and then stop talking entirely. Not because you have something to hide, but because nothing you add from that point forward can genuinely help your situation, and a great deal of it can hurt it. If you take away one thing from this video, let it be this. Police are legally allowed to lie to you to get you talking, and your only real defense going in is knowing exactly which lines to expect and exactly how to respond. Silence, invoked clearly and out loud, isn't guilt. It's the one move in this entire interaction that can't be twisted into something it isn't. None of this is legal advice for your specific situation, and how it plays out can vary depending on where you are. If you're actually facing questioning or charges right now, talk to a licensed attorney in your area as soon as you possibly can. If this helped you understand what's actually happening in that room, hit like, subscribe, and turn on notifications so you don't miss what comes next. And tell me in the comments, has an officer ever tried one of these exact lines on you? Next time, we're going further into what happens after you invoke your right to remain silent, what police are still allowed to do once you've said those words, and what crosses the line after that.